Who owns the trademark very demure, very mindful? I'm wading into another trademark controversy. Come along with me. I'm Angela Langlots, trademark and copyright attorney. I go live here on weekdays to discuss trademarks and copyrights. So, another viral video has generated a trademark kerfuffle. This month, we have Jools LeBron and her very demure, very mindful video that went viral, and now it's generated a trademark controversy. Who's going to win? I have no idea, but here's the situation. So last month we had Haley Welch and her hook to a trademark. Somebody actually messaged me and said, "You're saying it wrong." Fine. So I said it wrong. This month, we have very demure, very mindful, and also it's generated some controversy for very demure, very cutesy, but I like very demure, very mindful. So I want to thank my friend for telling me about this, because now I can talk about another viral video generated trademark kerfuffle. So a woman went viral on the platform TikTok. She was discussing makeup and appropriate makeup for work. And basically it was, hey ladies, don't go to work wearing crazy makeup if you came to the job interview wearing conservative makeup, because the conservative makeup look was what you were hired for, the very demure, very mindful makeup. Okay, so the whole thing, for whatever reason, goes viral. I only partly understand virality. The Haktua video went viral because it was funny. This one isn't really even funny, in my opinion, but what do I know? I'm just some attorney on the internet. But I don't think it's very funny. I don't think it's very noteworthy, but other people liked it, so it doesn't matter what I think. I have no idea why it went viral, but it did. So it went viral, and she has since made other videos using the phrase very demure, very mindful, and also using the phrase very demure, very cutesy. Fine. In none of those videos, however, is she offering any goods or services. Now, in order to have trademark rights, you have to use the trademark in conjunction with the offer of goods and services or the display of goods and services. There has to be some association between the trademark that you're claiming ownership of and goods and services that you are offering to other people. It doesn't matter if you're getting paid for the goods and services. That's not important. The important thing is that you are offering goods and services in conjunction with the use of that trademark in commerce. What is in commerce? It just means that it's in more than one state or in commerce that Congress can regulate. I'm not going to go into that here. We would be here all day. So this video went viral, and then guess what happened? Did this woman file a trademark application? Oh, heck no. If she had filed a trademark application in a timely manner, we would not be here talking about it now because there wouldn't be a controversy. But here's what happened. On August 20th, a man filed a trademark application for the trademark very demure, very mindful. I'm going to shrink myself into the corner and show it to you right here. Here it is. His name is Jefferson Bates. And I don't know why, but that name just kind of reminds me of like Bates Motel, right? It makes him sound unsavory, and he probably is a little unsavory, which is why he filed this trademark application. And then, as if to avenge his theft of the trademark application for very demure, very mindful. You can see the trademark listed here. It was filed on August 20th. On August 24th, some woman named Kassandra Pop, this is weird name central here, filed very demure, very cutesy. Apparently, that is a phrase that Jools LeBron also uses, and there was no trademark application filed. So she thought that she would strike a blow for justice and apply for that so that Jools LeBron wouldn't miss out on the trademark. It's all a very funny situation. what can we learn from this? What we can learn from this is, if you have something go viral, for God's sake, get to the trademark office and make that filing as soon as you can. You can file a trademark application for goods and services that you're not even using the trademark on yet. It's called an intent to use trademark, and we use them all the time in order to protect somebody's trademark rights while we are beginning to use the trademark. So it buys us some time. It is a limited opportunity for you to essentially squat on trademark rights that's otherwise not available, okay? So thing number one, if you have a trademark, get into the trademark office and file that trademark application right away. Number two, for God's sake, get some trademark advice before you file that trademark application, because once you file the application, you can't make any material changes, excuse me, to the application. You are stuck with whatever it is that you filed. If you make a mistake, yes, you can refile, but you're going to have to pay again all of the trademark filing fees when you file again. Okay, so try to get it right the first time. The best way to get it right the first time is to get some trademark advice and then go file. So what's going to happen next? We have this trademark kerfuffle that is probably going to be litigated because there's a lot of money at stake here. He didn't file, this Jefferson Bates guy, he didn't file for t-shirts or some cheesy merch. He actually applied to register the trademark for advertising and promotional services, the same sort of services that Jools LeBron is hoping to get some traction with as an influencer. So this is every influencer's dream. You go viral, people like you, and then people contact you to promote their stuff. But you can only do that if you're not infringing somebody else's trademark while you're doing it. And this guy, this Jefferson Bates guy, has a trademark filing on the record that is superior to any apparent rights that Jools LeBron has. So now what? Well, she can oppose at the appropriate time. She should first file her own trademark application. And then when the trademark of Jefferson Bates comes up for examination, there is a time which you can file something called an opposition. So she can file an opposition to his trademark and basically say, hey, I'm the true owner of the trademark. You can do that, but it's going to cost you extra money because you didn't timely file. So for gosh sake, just get into the trademark office, file, and then you can have more rights to do whatever it is that you want to do with that trademark. But until you've got that trademark application filed, you're going to have a really hard time laying claim to any trademark rights and enforcing any trademark rights. Why Jools LeBron still doesn't have a trademark on file, I have no idea, but let's hope that her counsel has a plan to remedy that. I'm Angela Langlots. I go live here to talk trademarks and copyrights. If you have trademark and copyright law questions, drop them into the comments below. I'll answer them on a future live. Find me on the internet, on Facebook and on YouTube. Like and subscribe to get all of my newest material.